Legal Pond.
Welcome to today's episode of the Legal Pond. If this is your first time joining us here, kindly subscribe to the channel and click on the notification button so that you'll be notified anytime we upload a new video. Today's video is going to be on terms of contract. Terms of contract. Now, this topic is one of the longest we have in the law of contracts. And for you to understand the topic well, I am going to break it into two different episodes. Today's session is going to be on ascertaining the terms of a contract and the classification of terms of a contract. Afterwards, I would record another video that will take you through the second aspect of the topic, which will be on standard form contract and exclusion clauses. Let's get started.
The Legal Pond.
Welcome back. As I said earlier on, today's episode is going to be on terms of contract, but I'm going to focus on the ascertainment of the terms of a contract and the classification of the terms of contract. Now, what is a term of a contract? You realize very well that anytime people are about to enter into contract, they talk, they enter into negotiations, and at the negotiation stage, they make a number of statements. They make several statements, which some of them are meant to be binding and others are not. So, for instance, I want to sell my car to you. You come to my premises. I tell you that my car is A, my car is B, my car does this, my car does that. Now, I have given a lot of information. You also give yours. Oh, I have this amount of money. I want to do this. I want to use the car for this. You realize that we are going to say a lot of things. Now, among all these things that we say as parties to the contract, there are some of them that we may intend it to be binding on us. There are some that are not meant to be binding. Now, those statements which we intend for them to be binding on us is what we call the terms of our contract. And the ones that we merely said it without intending it to be binding are called representations. So terms of contract are meant to be binding on the parties, whilst representations are meant not to be binding on the parties. What representations does is that it induces the parties to enter into the contract. So we are looking at the type of statement or the kind of statement that is meant to be binding on the parties, which is known as the terms of a contract. Now, the parties have entered into negotiations, they have talked, they've said a lot of things. How are we going to differentiate the terms from the representations? The court has certain guidelines, certain pointers that they look at to come to the conclusion that this is a term and it is different from that which is a representation. So what are the things that the court will look at? So what I want us to look at right now is the ascertainment of the terms of the contract. The kind of things the court will look at to come to a conclusion that yes, the parties have a contract or this is a term of a contract. One of the things that the court looks at to come to a conclusion that a particular statement qualifies as a term of a contract is the relative importance attached to the statement. If a party makes a statement and after considering that statement and comparing it with other statements made by the person, we realize that the person plays some kind of importance or the parties place some kind of importance to that statement, then that statement to which that importance is placed becomes a term of the contract and not a mere representation. So for instance, you look at a case like Bannerman versus White. You notice that in this case, the plaintiff wanted to buy hops, and then he told the seller, who is the defendant, that I will not buy it if it has been treated with sulfur. So you see the importance he placed with that statement, that he will not bother himself to ask of the price if that particular hops, if that particular thing that he wants to buy contains sulfur. So that importance that was placed on the statement made the statement a term and not just a mere representation. So when it happened that after the sale, you realize that the hops contained sulfur, that particular statement, even though it wasn't written, it was considered as a term of the contract, and that the defendant was held to have breached the contract for selling hops that contained sulfur. So one thing that the court looks at is the relative importance placed on the statement made by the parties. And the authority I've given is the case of Bannerman versus White. Another thing that the court looks at to come to conclusion that yes, this is a term and it is different from a representation is when the parties exercise what we call verification rights. Now, if you want to purchase something from me and I tell you to come and verify, and then you tell me that, oh, you wouldn't verify because you trust me or because you believe it is okay, that statement that you've made will be considered as a term of the contract, such that if it happens that after purchasing the thing, you notice there was a fault with it, you cannot sue me for that. You cannot sue me for breach of the contract because you failed to exercise your right to verify. It can also be that you wanted to verify, but I told you to stop because the thing is okay. Now, when I stop you from verifying, when I stop you from exercising your verification rights, then me stopping you and assuring you that the goods is in good condition for you to purchase becomes a term of the contract. Say that if at the end you realize that that particular property I'm giving to you, that particular good I am giving to you is not of the quality I assured you of, then you can sue because that thing I said becomes a term of a contract. When you look at a case like Ike versus Godfrey, where the plaintiff wanted to buy a boat from the defendants, and then he asked whether the boat was in good condition. The defendant said that as far as he is concerned, he knows that the boat is in good condition. But then Ike, who is the plaintiff, can bring his own engineers to come and test or verify the quality of the boat, which the plaintiff did not. So in this case, you realize that the plaintiff waived his right of verification. And because of that, when it happened that the boat was not sound, he couldn't enforce that statement as a term of the contract. There is another case of Shower versus Reed, where the plaintiff wanted to purchase a horse from the defendant, and then he asked whether the horse was sound. The defendant said yes. He said, let me verify. He said, oh, you don't have to verify. It is sound. So that statement now becomes a term because he has prevented the plaintiff from exercising his right of verification. Shower versus Reed. Another thing that the court looks at to determine whether something is a term and differentiate it from a mere representation is the relative knowledge of the parties. If the two parties who are entering into the contract are not of the same knowledge concerning the subject matter of the contract, then whatever statement that is made by the party with the relatively higher knowledge will be considered as a term. So you look at a case like the Bentley Motors versus Harold Smith, where the plaintiff wanted to buy a vehicle from the company, and they told him that the car has traveled 20,000 miles since its engine was changed. Now, the plaintiff did not verify and believed the same to be true. Now, later, he realized that the car has actually traveled more than the 20,000 miles as was stated by the seller. So he wanted to enforce that statement made by them against the sellers. The court said, looking at Harold Smith as a car dealer, he was supposed to verify to know whether that statement that was made was right or wrong. So in this sense, what was said to him that the car has traveled 20,000 miles was a term, looking at the knowledge he possesses as a car dealer. There is this case of Oscar Chess versus Williams, where two people were engaged in the sale of a car. Now, both the seller and the buyer had no knowledge on the models of car. So the seller told him that, oh, my car is a 1948 model, even though it was 1939 model. But both parties did not know or did not have knowledge on how to ascertain the model of a car. So in that sense, you realize that what the party said cannot be considered as a term because they do not have knowledge on the subject matter. Another guideline that the court used to ascertain the terms of a contract is when the terms of the contract has been reduced into writing. Now, if the parties, after their negotiations, reduce some of the things they said into writing, then the court will treat what has been reduced into writing as the terms of the contract. What it means is that the presumption here is that what the parties did not put into writing is something that they don't intend it to be binding. You can look at the case of Rutledge versus Mackay. Now, this idea comes from a principle or a rule called the Parole evidence rule. Now, the Parole evidence rule is to the effect that the court will not admit any extrinsic evidence to vary the terms of a written document or the content of a written document. You can look at that under section 177 of the Evidence Act 1975, Act 323, or you can say NRCD 323. And then cases like Opong versus Anefi, and the case of Wilson versus Broby, there are a number of cases. So if the parties reduces what they've said into writing, then generally the court would consider what is written over what was not written. So you look at the case like Dua versus Yokwa. The court said whenever the court is faced with oral evidence and documentary evidence, the court will stick to the documentary evidence. The court will be more inclined to the documentary evidence. Now, there are exceptions to this Parole evidence rule. There are conditions under which the court will admit Parole evidence to vary the terms of a written document. What are those conditions? One of them is that Parole evidence or oral evidence or extrinsic evidence will be admitted to vary the terms of a written document if that Parole evidence is given to prove what you call non ex factum. Now, non ex factum means that you are telling the court that what you have signed or what you have engaged yourself in is not what you intended. It is not your deed. So non ex factum simply means this is not my deed. Now, to be able to rely on the doctrine of non ex factum as an exception to the Parole evidence rule, you must be able to tell the court that what you signed up for is entirely different from what you intended. 2, you must demonstrate to the court that you have made a mistake as to the general character of what you intended. And then 3, you weren't careless. Now, talking about carelessness, if the document is given to you for you to sign and then you don't read before signing, or you had the opportunity to read but you failed to read and went ahead to sign, in that sense, you have been careless, and because of that, you cannot rely on non ex factum to bring extrinsic evidence to vary the terms of the contract or of the written document. So you may look at cases like Lewis versus Clay and a case like Angler Building Society versus Saunders, where this woman signed a document that allowed her to mortgage her property without reading just because she has left her reading glasses in the room. That was carelessness. The court says she could not rely on the doctrine of non ex factum to vary the terms of that document that is written, that was signed. It was a mortgage document. Another condition under which extrinsic evidence will be admitted to vary the content of a written document or an exception to the Parole evidence rule is when the extrinsic evidence is brought on board to prove the existence of collateral contract. What is a collateral contract? A collateral contract is that contract which exists side by side with the main contract. So if you tell me that you would enter into this contract with me, but unless I agree to do A or B, now that A or B that you want me to agree to before we enter into the main contract becomes collateral to the main contract. So you look at a case like City and Westminster Property versus MAD, for instance. This guy was a tenant at a premises, and the premises, according to a written document, was supposed to be used for business purposes only. He wasn't supposed to reside there. It wasn't supposed to be used as residential premises. So this guy said, if that is the case, then I want to leave. The landlord said, oh, don't leave, because I will allow you to use the back side of the premises as your residence and use the basement as well. So this guy agreed and signed the document, even though the written document said it wasn't for residential purposes. Now, the landlord wanted to enforce what is in the written document, stating that that is the term of the contract. But the court said no. Once there was a condition which made the guy to enter into that contract, that condition becomes a collateral contract to the written document. And because of that, the court will admit that condition, that collateral contract, which says that I will allow you to sleep here or use here as residential premises if you enter into the tenancy agreement. So the court may admit extrinsic evidence to prove the existence of collateral contract. And I said collateral contract is a contract that exists side by side with the main contract. Sometimes too, the court can admit extrinsic evidence to vary the written document to prove the existence of trade custom. Another exception under which extrinsic evidence will be admitted is when the extrinsic evidence is given to prove the existence of a vitiating factor, whether it is duress, undue influence, misrepresentation, mistake, or what have you. Also, if the contract is contained in a signed document, the general rule is that all the parties to that contract are bound to the terms contained in the signed document. The rule concerning signed documents is that once you append your signature to them, they are binding on you. So unless probably you are trying to prove non-ex factum or illiteracy or any of those exceptions we have talked about. Now let us look at illiterates and written documents. Are illiterates bound by written documents? Because we know that when the document is written or signed, the parties are deemed to be bound by it. The contents of such documents are deemed to be the terms of the contract. What if one of the parties is an illiterate? At common law, the position is a bit different from what we have here in Ghana. So you look at the case like Thompson versus London, Mainland and Scottish Railways, for instance. The case held that illiterates are still bound by written documents. But then in Ghana, the position is a bit different. In Ghana, the case of Zabrama versus Segbezi has defined illiterates to mean someone who does not understand the language in which a document has been prepared. So it doesn't matter whether you have schooled or not. If the language in which the document is prepared is something that you don't understand, then for the purpose of that particular document, you are an illiterate. This definition was given by Pega J.A. in the case of Zamrama versus Segbezi. Now, the law in Ghana can be found under Section 4 of the Illiterate Protection Law, Cap 262. And it says that for an illiterate to be bound by a document, all the things under the Section 4 must be clear, must be satisfied, must be demonstrated. And the things there, when you summarize it, it says that the person who is entering into that contract with the illiterate must make sure that the document is being read and interpreted to the illiterate in a language that he understands, and be convinced that the illiterate has understood the nature of the document before that illiterate could be bound. Now, previously, the law was that for us to be convinced that yes, the illiterate understood whatever he signed, there must be a clause in the contract that shows that, or that tells that the illiterate understood whatever is contained in that particular document. And that clause is what you call the jurat clause. So you look at the case like Atta Kwame versus Kufuor. In those early cases, you realize that without jurat clause in the contract, the document will not be binding on the illiterate. But then later cases like Diodu versus Adomako and Adomako, the case of Wiafe versus Com, the case of Ray Okai and Co, makes us understand that the existence of jurat clause is not a compulsory requirement, provided there is evidence that the illiterate understood the nature of what he was doing. If there is evidence that he understood what he was doing, then there is no need to show a jurat clause or to demonstrate it or evidence it by a jurat clause. Once we are convinced, all right. So let us look at the classification of terms of contract. Now, terms of contract could be express or implied. The parties can expressly indicate their terms of the contract. Sometimes the parties may not expressly indicate the terms of the contract, but then some terms will be implied into the contract. So how are terms implied into contracts? The terms can be implied by statute. The terms can be implied by custom, or the terms can be implied by the court. What are some examples of terms that are implied by statute? A typical example is Section 50 and 51 of the Land Act 2020, Act 1036. You realize that those sections puts what we call implied conditions in any tenancy agreement. So if you are alienating the premises to a person, the tenant is supposed to comply with all the provisions under Section 51, even if you don't indicate it in the contract. The same way, when you look at the Sale of Goods Act, Section 14, for instance, will let you know that there are implied conditions as to quantity of the goods to supply. So if, for instance, I ordered for 20 bags of rice and you supply 5, Section 14 of the Sale of Goods Act allows me to reject the goods. Even if we don't state it in the contract, that term is implied by statute. The statute has fixed it for us. So terms can be implied by statute. Sometimes too, terms of the contract can be implied by the court looking at the facts of the case. So the parties may not have stated that ABC should be in our contract, but then the court can look at the fact of the case, the circumstances surrounding the contract, and imply terms. And the court does that to ensure what you call business efficacy, as was noted in the case of the Mukok. The Mukok was a case that involved a ship which docked on a jetty belonging to the defendant. And the jetty was at a particular place where there were some stamps at the bottom of the sea. So when the ship docked, it sustained injuries, and then they sued the owners of that jetty for that particular injury that has happened. And they were claiming that it wasn't in their contract to make sure that the seabed is safe. But the court said, if you have a jetty and your seabed is not safe, then what is the purpose of the jetty? So you realize that the court fixed that particular term to make sure that the contract has a meaning, to make sure that the contract makes sense, to ensure business efficacy. Now, terms of contract can be implied by way of custom. Now, if there is a trade custom that we all adhere to, and then we don't state it in our contract, that custom can be implied as a term in our contract. So for instance, let's assume we are into mango business. We sell mangoes, and then I order mango from you. But you see, those who sell mangoes, they have this box that they keep the mangoes in so that it doesn't get destroyed. They have some special box. It is their style of trade. So let's assume when we contracted, I did not tell you to put it in the box, or we did not put it in our contract that the mangoes should be put in that box. If you fail to put in that box, because that particular practice is a custom, it may be considered as a term, and then you may be deemed to have breached the term of the contract for not keeping the mangoes in that box. So you look at a case like Hatton versus Warren, where a tenant farmer was quitting his tenancy, and then he said by custom he was supposed to get some of the proceeds, some of the manure, and a lot of things like that. It was their practice, so the court allowed it as a term, even though it wasn't in the tenancy agreement. You may also look at the case of Kwate versus Noga. That case says that if there is a custom, then you should prove that the custom exists, the custom is accepted by the people, and then you shouldn't have contracted outside the custom. So if you say that something is a custom, it should be something that is widely practiced by the people who are involved in that particular industry. So using the mango issue, for instance, if some of the sellers in the industry uses that practice or goes by that box, and then some do not do it, then that practice has not received a wide acceptance, and that it cannot be a custom. Let us also look at this. Now, whether the term of the contract is express or implied, it can be reclassified into 3 major heads. We have some of the terms of the contract which are known as conditions. Others are also known as warranties, whilst others are known as innominate terms. What are conditions? Now, conditions are those terms of the contract, whether express or implied, that when you breach, the breach goes deep to the root of the contract, such that it changes the nature of the contract. Once you breach it, it changes the nature of the contract, and that it entitles the innocent party to rescind the whole contract. They are called conditions. It goes to the root of the contract when breached. So if you look at a case like Pausad versus Spears and Pond, for instance, a singer was booked to perform at the opening ceremony of an event, but she fell sick on that day. However, the events were in series. She failed to perform on the first day because she fell sick. She later recovered and came back and wanted to continue from wherever they have gotten to. The event organizers did not allow her to perform. Now, when the matter got to court, the court treated her failure as a breach of condition because her failure to attend changes the nature of the contract. We wanted you to perform on the ceremony day. It is over. The ceremony is over. The opening ceremony is over. So even if you come and perform, it will be different from what we wanted you to do. That is a breach of condition. Then there is another type of term of contract, which is known as warranties. Now, these warranties, when you breach them, it doesn't really go down to the root of the contract. And because it doesn't go to the root of the contract, it does not entitle the innocent party to rescind the contract. It only entitles the innocent party to claim damages. The authority for this is the case of Bettany versus Guy. Now, in Bettany versus Guy, the plaintiff has been booked to come and perform at an event, but then she was supposed to go for rehearsals before the main event. But she fell sick and couldn't make it for the rehearsals, but she made it for the event. Now, you realize that per the terms of the contract, she was supposed to come for rehearsals. She couldn't come, but at the event, she was there. So you realize that she has breached the contract, but what she has done does not go to the root of the contract because she was present at the main event. So breach of that particular term that requires her to come for the rehearsals wouldn't go to the root of the contract. And that the innocent party could only claim damages and not have the right to rescind the contract. Then there are other terms of contract called innominate terms. Now, innominate terms, as their name suggests, they do not have a particular name, whether condition or warranty. You cannot tell what they are from the beginning unless the breach has happened. And this type of term of contract was propounded in the case of Hong Kong Fair Shipping Company Limited versus Kawasaki Kaisen Kaisha Limited, where in that case, the plaintiffs have given their ship to the defendants on a 2-year lease for a particular voyage, and then they stated in the contract that that particular vessel, the ship, is seaworthy. Now, due to some incompetent maintenance and crew member performance, the voyage delayed, but subsequently they were able to get to their destination. Now, they didn't want to pay because of the delay, because they were saying the ship or the vessel was not seaworthy. That's why it caused the delay. Now, this particular term, right from the beginning, you cannot tell whether it is condition or warranty. So the court said, Lord Diplock said that for innominate terms, we are able to determine whether they are condition or warranty, looking at the effect of their breach, looking at the seriousness of the effect of their breach. Now, considering this particular case, for instance, when the term was breached, it did not really affect the benefits that they were supposed to enjoy under the contract. Once it did not affect their benefit, then the breach is not too severe to ensure that the contract is being terminated. So all that they could do is to claim damages, because what has happened right now was not a breach of contract, it was a breach of warranty. But then it couldn't have been told from the beginning or from the onset. So such terms that you cannot tell what they are from the onset are called innominate terms. So these are the 3 types of terms of contract, whether express or implied. They can be condition, warranty, or innominate terms. If you have any question, you can contact the numbers on the screen and send your concern, or put it under the comment section for an address to be made. Once again, subscribe to the channel, click on the notification button so you'll be notified anytime we upload a new video. I also encourage you to get the legal companion and answer the questions therein on this particular topic. Once again, note that this video is not a substitute to lectures. See you in our next episode.
The legal pond.